Notes on the survivor's liability to the transferor's creditors. It comes after the de facto merger and the corporate combinations, tender offers, and defending control part of the book. Chapter 14 of the case book on page 1010. Traditional corporate law orientation. Stock for assets transactions are often used in preference to a statutory merger or a stock for stock combination because so stock for assets is preferred over statutory or stock for stock combination because of a desire to avoid assuming the acquired corporation's liabilities, particularly undisclosed or contingent liabilities. In a statutory merger, the surviving corporation becomes liable by operation of law for all of the transferor's obligations, including those that are contingent or undisclosed. In a stock-for-stock combination, the survivor does not become directly liable for the debts of the acquired corporation, although the acquired corporation is now a subsidiary of the survivor and carries its obligations along. So, how are they not directly liable? The survivor does not become directly liable for the debts of the acquired corporation, although the acquired corporation is now a subsidiary of the survivor. Okay, so that's the acquired organization's liabilities. In contrast, in a stock for assets combination, the survivor may remain free of those liabilities. It does not expressly assume on the theory that it merely engaged in a purchase. Frequently, however, this theory is not accepted by the courts. The following formulation on one very much like it is found in a great number of cases. This is a general rule is that a mere sale of a company of corporate property by one company to another does not make the purchaser liable for the liabilities of the seller not assumed by it. There are, however, certain exceptions to this rule. Liability for obligations of a selling corporation may be imposed on the purchasing corporation when 1. The purchaser expressly or impliedly agrees to assume such obligations. 2. The transaction amounts to a consolidation or merger of the selling corporation with or into the purchasing corporation. 3. The purchasing corporation is merely a continuation of the selling corporation. Or 4. The transaction is entered into fraudulently to escape liability for such obligations. So that's the general rule and the exceptions. Where the second or third exceptions apply, many, though not all cases, make the survivor in a typical stock for assets transaction liable to the transferor's shareholders under a de facto merger theory. Successor liability through the product liability lens. When the claim against a successor corporation raises from a defective product, a significant number of, albeit a minority, of the states reject the formal corporate standards for successor liability and instead are guided by the policies underlying product liability claims. The leading case for this approach involved Robert Ray, who was seriously injured by a defective ladder manufactured by Allied Corporation, Allied 1. Prior to Ray's injury, Allied 1 sold its cash for assets to the defendant, Allied 2, who continued to manufacture the same line of ladders under the Allied name, using the same equipment, design, and personnel, and soliciting Allied 1's customers through the same sales representatives with no outward indication of any change in the ownership of the business. So this is a tort judgment, I'll just say, example. And the court said the insulation from the predecessor's liabilities of a corporation acquiring business assets has the undoubted advantage of promoting the free availability and transferability of capital. However, the advantage is outweighed under the narrow circumstances here presented by considerations favoring continued protection for injured users of defective products. These considerations include the non-availability to plaintiff of any adequate remedy against Allied 1 as a result of Allied 1's liquidation prior to plaintiff's injury, 2, the availability of Allied 2 of the knowledge necessary for gauging the risks of injury from previously manufactured ladders together with the opportunity to provide for the meeting the cost arising from those risks by spreading it among current purchasers of the product line, and 3, the fact that the goodwill transferred to and enjoyed by Allied 2 could not have been enjoyed by Allied 1 without the burden of liability defects. In ladders sold under its aegis. Accordingly, we have concluded that the instant claim of strict tort liability presents an exception to the general rule imposed by against imposition upon a successor corporation of its predecessor's liabilities, and that summary judgment should be reversed. And then the citation for that is like incredibly long. So I'm going to skip all that, and we're going to move directly into part E, triangular mergers. And share exchanges. Notes on triangular mergers, share exchanges, entity conversions. Triangular mergers. A statutory merger is often preferable to either stock for assets or a stock for stock combination. To begin with, the Internal Revenue Code provides greater liberality as to the type of consideration that can be given to an A reorganization, a statutory merger, than in a B reorganization, a stock for stock combination, or a C reorganization, a stock for assets combination. See section 1D supra. Furthermore, a stock for assets combination may involve sales tax as well as statutory merger ordinarily will not. That's interesting. That's a big difference. A stock for assets combination also ordinarily involves a great amount of paperwork in the form of deeds and assignments of the transferor's property, and in some cases, notice to creditors in compliance with the applicable bulk sales law. In contrast, in a statutory merger, the survivor succeeds to the transferor's assets by operation of law, so that neither individual documents of title nor compliance with the bulk sales law is ordinarily required. I'm just going to write at least down the fact that stock for assets involve sales tax and deeds, assignments of transferor's property. So I didn't pick that up in the earlier reading. On the other hand, in a statutory merger, the surviving organization assumes the disappearing corporation's liabilities by operation of law. Furthermore, the statutory merger normally triggers voting and appraisal. I write this down too. So it's not ordinarily taxed, and it assumes liabilities of, I'm just going to say target, and triggers, we do know that it triggers voting / appraisal rights. Okay. In the shareholders of both constituents. Now, in contrast, in the stock for stock or stock for assets combination, the acquiring corporation does not necessarily assume the transferor's transfer corporation's liabilities. Okay, and that's the same with the stock for stock. Moreover, these forms of combinations may require vote only by shareholders of one constituent and may not trigger appraisal rights. Accordingly, the management of the corporation that proposes to engage in a corporate combination may prefer to use the statutory merger form, except for the voting and appraisal rights entailed by that form. The triangular merger is a technique designed to give management the best of both possible worlds, the form of a merger, but without necessarily assuming the liabilities of the disappearing corporation and without voting or appraisal rights in the survivors' shareholders. So that sounds like the definition. I'm not going to rewrite it this time, but it's on page 1012. And I think it's just a term for what we've been talking about in the last recording. Forward triangular mergers. A conventional or forward triangular merger works this way. Assume that corporations S and T want to engage in a merger in which S will be the survivor and T shareholders will end up with 100,000 shares of S. In a normal merger, this would be accomplished by having S issue 100,000 shares of its own stock to T's shareholders. In a conventional triangular merger, however, S instead begins by creating a new subsidiary, S sub, and then transfers 100,000 shares of its own stock to S sub in exchange for all of S sub stock. S sub and T then engage in a statutory merger, but instead of issuing its own stock to T's shareholders, S sub issues 100,000 shares of S stock. The net result is that T's business is now owned by S's wholly owned subsidiary rather than by S itself, as in a normal merger, and T's shareholders now own 100,000 shares of S stock. By use of this technique, S may therefore achieve the advantages of a statutory merger while insulating itself from the direct responsibility of T's liabilities. The final step is S using short form merger provision to merge S sub into S so that the assets and liabilities formerly held by T are now among the assets and liabilities of S. Such a transaction would probably not have been permissible under the traditional statutory merger provisions because those provisions usually contemplated that surviving corporation must issue its own shares or securities. However, the merger statutes of most or all jurisdictions have now been amended to permit the survivor to issue shares or securities of any corporation. That's crazy. In tandem with this development, the IRC, which is the Internal Revenue Code, was amended by adding section 368A2D, which permits the conventional triangular merger to qualify as tax-free. And reorganization if Romanet 1, substantially all of T's properties are acquired by S sub Romanet 2, the merger would have qualified as a reorganization if T had merged directly into S, and Romanet 3, no stock of S sub is used in the transaction. Okay. Reverse triangular merger. A reverse triangular merger proceeds like a conventional triangular merger, except that instead of merging T into S sub is merged into T, i.e. T, not S sub, survives. The merger agreement provides that all previously outstanding T shares are automatically converted into the 100,000 shares of S held by S sub, and that all shares in S sub, which are held by S, are automatically converted into shares in T. When all the shooting is over, therefore, S sub will have disappeared. T will be a wholly owned subsidiary of S, and T's shareholders will own 100,000 shares of S stock. By use of this technique, S may therefore achieve the advantages of a statutory merger while preserving T's legal status, which could be important where T has valuable non-assignable rights under contracts, leases, licenses, and franchises. Under IRC section 368A2E, reverse triangular merger will qualify as tax-free, and a reorganization if Romanet 1, so this is going to be 2 different note cards, clearly. T ends up with substantially all of the property of both S sub and T, and Romanet 2 S voting stock is exchanged for at least 80% of T's voting and non-voting stock. And Romanet, that is less Romanet. But it's tax-free, and I'm taking that note down. It's shocking. But anyway, an important problem raised by triangular mergers is that they may allow subversion of shareholder voting and appraisal rights. To avoid this result, it can be argued that despite the form of such transactions, voting and appraisal rights on the survivor's side are vested not in S as the sole shareholder of S sub, but pass through to S's shareholders. This argument was rejected in Terry versus Penn Central Corp. Supra, but that case was at least partly controlled by the unusual Pennsylvania legislative history. Which, if you remember, there's like this 908 protection thing that like finds a statutory merger, so that's probably what it is. Ideally, this problem should be dealt with by statute, for example, like rather than case law. For example, consider the role of MBCA, which is the Model Business, I guess, Corporate Code Act or something like that. 6.21, Model Business Corporations F, so requiring shareholder vote if shares are issued for other than cash and the number of shares so issued are more than 20% of the voting power prior to such issuance. The Model Act's provision parallels listing requirements of the New York Stock Exchange and NASDAQ. See also Cal Corp Code, Section 1200D, 1201. A merger reorganization must be approved by the shareholders of a corporation which is in control of any constituent corporation and whose equity securities are issued or transferred in the reorganization. All right, so this is either New York or California. Share exchanges, part 4. Another new mode of combination is known as share exchange. In a share exchange, the shareholders of the acquired corporation vote on whether to exchange their shares for designated consideration from the acquiring corporation. If the proposed transaction is approved by a majority of that corporation's outstanding shares, all of the shares must be surrendered, including those of non-consenting shareholders. Unless they exercise appraisal rights. 5 is entity conversions. Did I skip a page? I didn't. That was funny. As the entity grows, it usually is both practical and necessary to reorganize itself into a different entity. Thus, a business that began informally as a partnership may evolve into a limited liability partnership or LLC, and from there convert into a corporation. It could, of course, skip any intermediate step to become a corporation, and it is not unheard of for a corporation to become some form of unincorporated entity, a limited partnership. Modern statutes have made a process of entity conversion considerably more efficient. And there's an article about it discussing the earlier difficulties of reorganizing into a new entity before modern statutes authorized conversions. All entity conversion statutes have 3 core requirements. 1, a plan for conversion. 2, approval of the plan. And 3, filing specified documents with the plan. The plan referred to in its where did I just stop? I know it comes with 3 parts though. 3 core components. So let's start that up again. I was just highlighting the fact that this is a reorganization of an entity to a different entity. It requires a plan, approval of the plan, and filing documents with the state. The plan referred to in the statutes as either the plan of conversion or the certificate of conversion is generally brief, including the date the conversion will occur, the name and type of entity to be converted, and the manner of converting interest in the former entity. Approvals are in accordance with the requirements that apply to the original entity. Partners of the partnership and members of an LLC as provided in the operating agreement. The final step is filing with the Secretary of State a plan of conversion, certificate of conversion, as well as the document needed to form the new entity. Articles of organization for an LLC or articles of incorporation for a corporation. Most states have some version of the Model Business Corporation Act, Section 950 and 951, that straightforwardly sets forth the above described steps for converting incorporated business forms into corporate form and vice versa. Even further simplification is provided by a recently promulgated Model Entity Transition Act that is now adopted in a handful of states. So this is the minority and this would be the majority. While Delaware follows the same overall approach as outlined above, it does so by providing separate statutes detailing the conversion process into a desired entity. Thus, a Delaware conversion into a limited partnership is guided by 6 Del Code. So Title 6 of the Delaware Code of Section 15-1001 into a limited liability company, and Section 18-200 and sequential, and into a corporation by Section 26, well, Title 8 now, Section 265. Now, we're going to move into the freeze out section of this chapter, which will bring us to the next case. Just checking to see the length of this case. It's really so long that I'm not positive I didn't even get through it. But it's one of 2 cases on freeze out techniques. And then we'll talk about the purpose test, go into another 2 cases, 3 cases. The purpose test is a lot shorter. And Delaware's streamlined back-end merger procedure is something we'll read and then go into another case, followed by going dark, notes on going dark, which is still within the freeze out section. And that will bring us to hostile takeovers and defending control. So that is what I have left to read today. And therefore, might stop before freeze outs and do the rest in another recording.